Welcome to our continuing educational webinar series. I'm Catherine Short, Partnership Marketing Manager for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital network, healthcare practice of any size, billing company, or skilled nursing facility, and we help you manage every aspect of a compliance program, and our training library provides hundreds of modules that are easy to assign and track. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Rachel V. Rose, JD, MBA, Principal with Rachel V. Rose, Attorney at Law, P.L.L.C, Houston, Texas, with us today. Rachel has a unique background, having worked in many different facets of healthcare securities, cybersecurity, as well as international law and business throughout her career. Her practice focuses on a variety of cybersecurity, health law, and securities law issues related to industry compliance and transaction work, as well as representing plaintiffs in the Dodd-Frank False Claims Act whistleblower claims. In addition to being extensively published and sought-after presenter and quoted expert, Ms. Rose holds an MBA with minors in healthcare and entrepreneurship from Vanderbilt University and a law degree from Stetson University College of Law, where she graduated with various honors, including the National Scribes Award and William F. Blues Pro Bono Service Award. Ms. Rose is licensed in Texas and is admitted to practice before all state courts, as well as the United States Supreme Court, the District Court for the District of Columbia, and all four federal court districts in the state of Texas. She is a fellow in the Federal Bar Association, and currently she is the chair of the Federal Bar Association's Government Relations Committee, a board member of the Federal Bar Association's Key Tom section, the co-editor of the American Health Lawyers Association's Enterprise Risk Management Handbook for Healthcare Entities, second edition, as well as the co-author of the books The ADCs of ACOs and What Are International HIPAA Considerations. She has been named consecutively to the Texas Bar College and National Women Trial Lawyers Association's Top 25 and Houstonia Magazine's Top Lawyers for Healthcare. In 2019, she was also named the National Trial Lawyers Association's Top 100, as well as First Healthcare Compliance's 2019 Top Presenter. Ms. Rose is also an affiliated member with the Baylor College of Medicine's Center for Medical Ethics and Health Policy, where she teaches bioethics. See www.rvrose.com for additional information. Before we begin, I would like to mention at First Healthcare Compliance, we strive to serve as a trusted resource for compliance professionals, and every month we celebrate their hard work and dedication with our Compliance Super Ninja recognition. Today, our team is turning the spotlight on Super Ninja Patty Crather, HR Manager and Accounts Payable Coordinator at Delaware Neurosurgical Group, PA. Patty says, working at Delaware Neurosurgical Group continues to be personally satisfying and challenging. The providers and support staff are the best I've ever worked with. I am able to use my past experiences and continually learn new things. Congratulations, Patty. Our team is honored to have the privilege of working with you. A copy of the slides is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion. Your Paycom and PMI certificates will be emailed to you following the broadcast. Your Paycom certificate will come directly from Paycom, and your PMI certificate will come from our email. There's no need to request either one. Additional CEU opportunities will be available to BC Advantage members. So Rachel, thank you and welcome so much. We really appreciate you being here today.
Thank you, Catherine, and thank you, First Healthcare Compliance, for having me present on a very timely and important topic. Today, I'm going to be talking about RaDonda Vaught Automatic Dispensing Cabinets, patient care, and the criminal conviction. As many of you know who have heard me present before, no presentation is complete without a disclaimer, and the information presented here today is not meant to constitute legal advice. Please consult your attorney for advice on a specific situation. Additionally, the information presented is current as of the original date of the presentation, and given the dynamic nature of the topic, participants are encouraged to check the relevant government websites for the most recent information. So, a couple of statements that have been in the media. First, I think when this case is tried and the facts come out, it's a mistake and it's not all her fault either. And then there are some real systemic problems with the way they dispense medicine through that automatic dispensing system. Now, these two quotes are something I want you to keep in mind throughout the presentation because they really do form the basis of the various proceedings in different forums which we're going to be going through. First and foremost, I'm going to begin with the persons and the government agencies involved. Next, I'll delve into the automatic dispensing cabinets. Then I'll segue into the general criminal process. I'm focusing on federal for two reasons. First, I'm not a criminal attorney, and second, the procedures for criminal procedure vary from state to state, and I am not licensed in Tennessee. But there are a lot of similarities in general between the federal criminal process and the individual states, but that's why it's absolutely imperative to make sure that you consult a criminal lawyer, especially on a state case, which this was in the state where it is being handled. From there, we'll go into a timeline of the events, the indictment, the sentencing, and some takeaways from both the legal side, but also the compliance side as hospitals and providers move forward. So first and foremost, Ms. Murphy is the deceased patient and her family. So on one side, we have the decedent, and then we have Ms. Vaught, who is the nurse and the defendant, and Vanderbilt University Medical Center. And as you know, I attended Vanderbilt for my MBA, and I do not have any legal affiliation, even though I am an attorney. The district attorney, and then CMS, the Centers for Medicare and Medicaid Services, the Tennessee Department of Health, and the Tennessee Board of Licensing Healthcare Facilities. We also have the Davison County Coroner and the Joint Commission all involved in this significant matter. So it's imperative to appreciate what automatic dispensing cabinets are. Well, first and foremost, ADCs are often integrated with electronic health record systems or medical information systems for the purpose of patient care and oversight of prescription drug utilization for both controlled and non-controlled substances. There are also ADCs that are used for various types of medical devices or even scrubs that medical professionals wear so that they can be tracked into either the hospital's procurement system and or into a patient chart. As you can imagine, if sutures are used in the emergency room or in the operating room, that might be a location for the non-pharmaceutical type of ADC. But this case in particular deals with the pharmaceutical ADCs. So what is an ADC? Basically, it's a cabinet or drug storage device or that electronically dispenses medications in a controlled fashion and tracks their use, replacing or supporting the traditional unit dose delivery drug system. ADCs are not new. In fact, they began being utilized in the 1980s, and by the 1990s, the use was prevalent in hospitals, and their safety and efficacy were studied. And these studies highlight highlighted then a couple of areas which are still relevant today. First and foremost, the mislabeling of drugs. That has been mitigated some as drug companies put the barcodes on the drugs, and as they were scanned in, that would be another compliance or safety measure that could be in place. Second, improperly filled dispensing cabinet. So is the right drug in the right place? Or is the right dose of a drug in the right place? Lack of safety record procedures. This still occurs today, and it is absolutely significant. Large numbers of doses dispensed. In light of the opioid crisis, ADCs in particular have been known to play a role because, as we'll see here, and the last portion highlights this, the ability to override the system access tracking system. This creates an opportunity for diversion of controlled substances and other drugs by healthcare professionals. So all of these issues that, again, were highlighted approximately 20 years ago are still very, very relevant today. Now, ambulatory surgery centers and physicians' offices, which have a surgery practice, also utilize ADCs, so they're quite common throughout the healthcare industry. Here is an example of an ADC, and if you recall, I mentioned the two different types, one being the pharmaceutical one, which for anyone who's ever been in the hospital or visited someone in the hospital, those carts that are in the hall that the nurses often push around from room to room when it's time to dose medications, that is typically an ADC. Oftentimes you see a computer screen which enables the practitioner to, in fact, access the electronic health record. So here we have one, as you can see here, she's scanning a barcode, and then that would then register into whatever program this particular ADC is integrated into. This is more of a surgical ADC. As you can see, the different types of packs, as they're called, that are used for different procedures. You have the gauze, you have, or the 4x4s are sometimes referred to, and then you have the different sutures and other types of items in there. So how do they work? Well, for the ADC regarding pharmaceuticals, the doctor orders medication through the system, and I'm speaking more of a hospital setting or an ASC. So the doctor orders the medication through the electronic health record system. It goes to the pharmacy, and the pharmacy checks or should check the drug and approve it. From there, the system, if it's on the cart, should allow for dispensing, but all of these steps need to be documented. From there, there are oftentimes a two-factor identification that's required, and here it says deliver drug with fingerprint. Well, two-factor authentication, for those of you who have taken my HIPAA presentation, is basically two different types of ways to authenticate that the user is in fact the user. And typically one can think of an ATM card in our daily lives. And the way to think of two-factor authentication is one that you have and one that you know. So with an ATM card, your ATM card would be the one that you have, and your code that you punch in would be the one that you know. A similar type of mechanism can occur with a fingerprint as the one that you have, and then a follow-up would be the username and password, for example, would be the one that you know. The system then updates the patient profile and the drug is dispensed. So where are there potential pitfalls in the system according to those studies? Well, it can occur really at any point, but one item that's not on here is the stocking of the drugs. Another item is what goes on between the purple and the orange circles. And that's where you can have human error involved. You can have intentional human conduct where they circumvent these safety mechanisms and go around to gain access to the drugs. So there are a lot of different ways that this is problematic in the delivery of patient care. Now, does it make sense to have an occasional override? Absolutely. If there is a storm or there is a malfunction, one absolutely has to have a way to get into that cabinet. And so very few people, a common sense way would be to have a key, but very few people should have access to that key. Unfortunately, in my experience, speaking with a variety of nurses and other medical professionals, oftentimes multiple people have access to that key, so there's no real tracking when the key is utilized, or if there is a log, responsible organizations have a log where there's an input when a key is utilized and the system needed to be override and why it needed to be overridden. So those are things to bear in mind from the compliance standpoint. So what about the federal criminal process? Well, the federal criminal process is quite different from the civil side. And before I delve into criminal in general, importantly, only a government entity can bring a criminal case. A government entity can be the United States Department of Justice at the federal level. It can be the state attorney general's office at the state level, or at the local level, it can be the district attorney. So if you think in terms of who can bring a criminal case, that is the type of person who can bring a criminal case, the government. So at a very high level, as the DOJ states on its website, after the prosecutor studies the information from investigators and the information they gather from talking with the individuals involved, the prosecutor decides whether to present the case to the grand jury. Now, the grand jury is shrouded in secrecy, and grand jury is called in certain circumstances, and in other circumstances, depending on the type of crime, it is delivered in a different way. But when a person is indicted, they are given a formal notice that it is believed that they committed a crime. Now, the indictment contains the basic information that informs the person of the charges against them. So these are broad steps in the criminal process. First, the individual, typically there are 3 terms that are used. And for those of you who followed the unfortunate shooting at Highland Park in Illinois over the 4th of July, oftentimes when you hear or read about the person initially, the terms that were used were a person of interest, a target, or a subject. So they all have different meanings. Person of interest is different, and its use actually came about after the 1996 Atlanta City Olympic bombing. But really, once a person becomes a subject and a target, that's when it really people take notice. If you are on notice that you're even a person of interest, my advice is to get criminal legal counsel. Next, grand jury is formed and may request grand jury subpoenas to be issued. Now, what's important is that the use of grand juries to charge defendants is not required by all states, but it is a requirement in federal felony cases unless the defendant waives the grand jury indictment. Again, just this is one nuance between some of our state criminal proceedings and a federal criminal proceeding. From there, the prosecutor collects evidence and decides whether or not to present the case to the grand jury for indictment. From there, the charging, arrest, and arraignment take place if in fact there is enough evidence for an indictment to be issued. And as the previous slide indicates, the indictment is specific to the person to give them notice of the charges against them. From there, we go into important steps in the federal criminal process: the initial hearing and arraignment, discovery, plea bargaining, preliminary hearing, pre-trial motions, trial, post-trial motions, and sentencing. And oftentimes the appellate portion is very common in criminal law. So after sentencing, which is done in accordance in federal court with the federal sentencing guidelines, oftentimes the losing party will appeal. Not always, but it would then go to the federal circuit court and then oftentimes to the Supreme Court as well. So that is the process in a broad sense on the criminal side. Now, you may be thinking, going back to our first couple of slides, well, if that's the case, how did all of these entities get involved, these different government entities? Well, there is a reason for that. And oftentimes, as I see in my own cases, when I file False Claims Act cases on the civil side, the government always has the option of taking a case criminal through a False Claims Act. And this was not a False Claims Act case, but that's known as a parallel proceeding, when there is a criminal proceeding and a civil proceeding. You can also have parallel proceedings, and we'll delve into this a little bit more here, when you have a proceeding in front of a licensure board or another government agency. And so all of this was a more complex case, and especially in the pre-trial motion phase, or even during trial, one might file a motion to stay the proceeding until an outcome in one of the parallel proceedings has finished. That's very common. And those are just things to be aware of in this broad process. So what is the timeline here? Well, this is key, and the Tennessean did an absolute amazing job with the timing and the coverage on this case. It's very detailed, and it really was pretty balanced. So in October 15, RaDonda Vaught, who is the defendant in the proceedings, who was a licensed nurse, began working at Vanderbilt University Medical Center, the largest hospital in Nashville and one of the most respected hospitals in the nation. On December 24th of 2017, Ms. Murphy, who was 75 at the time and a longtime resident of the Nashville suburb of Gallatin, checked into Vanderbilt with what's known as a subdural hematoma, which means bleeding in her brain. So hematoma is another name for a bruise, but obviously that's internal, and subdural has to do with the levels in our spinal cord and in our brain. So you have dura mater, you have pia mater, and you have arachnoid mater. And so subdural is below the dura, and typically it's in the subdural space. So here on December 26th of 2017, Murphy's condition improved and she was almost ready to be discharged from the hospital. But during a final scan in the hospital's radiology department, the patient is supposed to be given a sedative. For those of you who are familiar with the clinical side of healthcare, a very common sedative is known as Versed, but it is accidentally given a dose of vacronium. Now, this is a powerful paralyzing medication, and according to federal investigators, basically the drug left the patient brain dead, and the defendant allegedly admitted to hospital staff that she was responsible for the medical error. So on December 27th of 2017, the patient's family gathers at the hospital to pay their last respects, and she dies at about 1 a.m. after being disconnected from a breathing machine. The items that are placed in bold are significant because first, later that day, 2 Vanderbilt neurologists report the patient's death to the Davidson County medical examiner without mentioning either the medication error or the vecurnomium, and that is very material, as we'll see. Murphy's death is attributed to bleeding in her brain and deemed to be natural, which is slightly perplexing because if we go back on the timeline, the hematoma had been made under control, and it appeared that there was no more bleeding in the brain, and that scan was being done just to make sure that everything was good to go. So based on the information provided by Vanderbilt, the medical examiner did not independently investigate the death. So medical examiner, another name typically for the coroner. So January 2018 rolls around, and in the wake of the patient's death, Vanderbilt officials take several actions that obscure fatal medication error from the government and the public. And in speaking with my criminal attorney friends, as well as when I advise my own clients, one of the worst things you can do is lie in general, but in particular, lie to the United States government or a federal or state agent of a government agency. So basically, the medical center is not reported to state or federal officials, which is required by law, or the Joint Commission, an accrediting agency that recommends but does not require reporting. Subsequently, the nurse is fired by Vanderbilt University Medical Center. So that's the high-level overview of the case. Now we get into the events that lead up to the defendant's indictment. So in early 2018, the exact date is unknown, but Vanderbilt negotiates a settlement with the patient's family that requires them not to speak publicly about the death or the medication error, and the settlement is not made public. Now, neither of these are uncommon, especially when there is a medical error and there is no public case. So the family agreed to this and a settlement was reached. Then we fast forward to October 3rd of 2018, and an anonymous tipster alerts state and federal health officials to the unreported medication error that was responsible for the patient's death. So up until that time, there was a concerted effort by the medical center not to make any of these issues known. As we know from the previous slides, the coroner or medical examiner did not do an independent evaluation because of what was on the death certificate, that it was a natural cause of bleeding in the brain. So on October 23rd, the Tennessee Department of Health, which is responsible for licensing and investigating medical professionals, decides not to pursue disciplinary action against Nurse Vaught. And in a letter to Vanderbilt, the agency's investigations director says the Vaught case did not constitute a violation of the statutes and/or rules governing the profession. Now that would be the nursing licensing board, which is separate from both the pharmaceutical or pharmacy licensing board and the medical licensing board. Now on the same day, Vaught is sent a letter saying this matter did not merit further action. So initially, everything is cleared by the licensing board, and she was still working as a nurse. Well, from October 31st to November 8th of 2018, in response to the anonymous tip, the Centers for Medicare and Medicaid Service conduct a surprise inspection at Vanderbilt, and this is permissible under the statutes. The inspection confirms that the patient died from an accidental dose, not of Versed, but instead of vecuronium, and that Vanderbilt did not report the medication error to the government or the medical examiner, according to an inspection report. Now, in late November, the circumstances of the fatal medication error become public for the first time. And it was actually CMS that releases an investigation report that details the error without identifying either the defendant or the patient. CMS took this pretty seriously and threatened to suspend the medical center's Medicare payments, crippling the hospital's revenue if Vanderbilt cannot prove it has taken steps to prevent a similar error. Vanderbilt quickly responds with a plan of correction that appeases the federal agency and secures its Medicare reimbursements. Now, if we go to 2019 now, the nurse defendant is publicly identified for the first time when she is arrested on criminal indictment for her alleged role in the patient's death. She is charged with reckless homicide and impaired adult abuse. And for those of you who are familiar, reckless, when you start seeing the term reckless or knowing, that's when you get into scienter. And scienter is corresponds to mens rea, which is the mental state at the time a crime is committed. And there are varying degrees that are associated with criminal law. And those of you may be familiar with first degree or second degree. This is reckless. And so it's not premeditated, but there is a reckless disregard. Oftentimes you see reckless homicide associated with drunk driving accidents as well. So on February the 5th of 2019, Vanderbilt executives speak about the fatal error during a meeting of the Tennessee Board of Licensing of Healthcare Facilities, which is responsible for disciplining hospitals. Again, that's separate from the nursing licensure board, which we'll see a little bit later. Now, Vanderbilt Health System's CEO admits the death wasn't reported to state regulators and said the hospital's response was too limited. The officials also confirmed for the first time that they negotiated a settlement with Murphy's family. The board takes no disciplinary action. So on February the 20th of 2019, Ms. Vaught makes her first appearance in court in her criminal case and enters a not guilty plea on all charges. March 27th rolls around, and in the court records, prosecutors reveal far more details about the case. First, they allege that Vaught made 10 separate errors when giving the wrong medication to Murphy. Again, take a step back and think of that arrow and circle cycle that goes around, overlooking multiple warning signs that she had the wrong medication. The court records state that if she would have looked directly at the warning saying paralyzing agent before injecting the drug, it would probably have averted the situation that occurred. And that was just one step. Now, on August 20th of 2019, at the request of law enforcement, the Nashville medical examiner re-examines the circumstances of the patient's death, and now aware of the medication error, the official manner of death was changed to accidental from natural. August 20th of 2019, at the request of the law enforcement, as I just said, it was changed to accidental, and that is actually material still, because if it was intentional, that could have had very significant implications for both the medical center as well as for the individual nurse. So September 27th of 2019, the Tennessee Department of Health actually reverses its prior decision not to pursue professional discipline against Nurse Vaught. Now, the agency officials charged her with 3 infractions before the Tennessee Board of Nursing, and the agency refused to explain why it reversed its prior decision. She is charged with unprofessional conduct, abandoning or neglecting a patient that required care, and failing to maintain an accurate patient record. Again, recall the ADCs are connected into the electronic health record typically, and failing to maintain an accurate patient record is significant. So from late October to mid-November 2019, because Ms. Vaught is now facing 2 legal proceedings, a criminal trial and a professional discipline hearing, a debate begins over which case should proceed first. Vaught's attorney attempts to delay the discipline proceeding until after her trial, arguing that if she defends herself by testifying in the discipline hearings, prosecutors may use that information against her at trial. Now, what's interesting is that attorneys for the health department opposed the delay and insisted that this nurse was an urgent threat to the public. And most of the department's substance of their argument was centered around her job at Centennial Medical Center. And for those of you who are familiar with Nashville and the healthcare systems there, Centennial Medical Center is HCA's flagship hospital, and it's located near the Parthenon, where she still at the time worked as a throughput coordinator. Now, an administrative judge, Elizabeth Cambron, decides not to delay the proceeding, saying Vaught's desire to delay this proceeding is outweighed by the seriousness of the allegations against her in the state court. So on December 15th of 2019, a Tennessean investigation reveals how actions taken by Vanderbilt officials actually obscured the circumstances of the patient's death, including delaying and hampering an investigation into the hospital. This is interesting because, as we know, the hospital, and especially their internal pharmacy department, most of the time it will be an internal department at the pharmacy. It might be one that is managed by an external entity. I do not know what the case is at this particular medical center, but the pharmacy is tasked with the restocking of the various pharmaceuticals in the pharmaceutical ADCs. So there is an active role. Another way that the hospital plays a role is in their compliance programs, which include policies and procedures, adequate training, and making sure that the mechanisms for both cybersecurity as well as patient care are in place with ADCs so that drugs cannot be diverted, so that there is a check and balance as to who is going in, and there is also a checklist to make sure that the nurses and other medical professionals who are able to dispense medications in fact do. So the story also includes the first public statements from Charlene Murphy's grandson, Alan Murphy, who is not constrained by the confidentiality agreement signed by other family members. A cover-up, that's what it screams, Alan Murphy said. Again, this is important because recall, there was a settlement with the family, but oftentimes for those of you who have ever reviewed settlements, especially those with a provision as to what can be said or who can say something or who cannot say something, it is critical to abide by that. Otherwise, there are downstream potential legal actions that can be taken, and the settlement can be unwound and have to be paid back. But in this case, the grandson, who was not part of the confidentiality agreement that was included in that initial settlement, had the ability to speak up. And he did. He said they, meaning the medical center, didn't want this to be known, so they didn't let it be known. The medical center, not surprisingly, declined to comment, and spokesman John Hauser said the hospital would not speak further about Murphy's death, quote, to avoid impacting either our former employee's right to a fair trial or the district attorney's ability to pursue the case as he deems necessary and appropriate. Both of those responses are very appropriate by the hospital. They might not have been palatable for the family and for others, but that is a valid response. Another thing to note is that in any, I will call it a crisis situation or a situation where an organization is at risk or an adverse event has occurred, it's imperative to identify one or two people to be the sole voices of the organization. That way, all of the communications are filtered, there is a record of them, and you don't have people going off the record or speaking on behalf of either the entity or the individuals. And that's absolutely important so that on the defense side or on an organization side, that you're speaking with one voice and that you are delivering a consistent message that has been vetted by the appropriate legal counsel. So we're now going to delve into the meat of the indictment and the parallel proceedings. So interestingly, only the nurse was criminally indicted on abuse and reckless homicide charges after she allegedly gave the patient the wrong medication leading to her death. There was no co-conspiracy or aiding and abetting charges brought against the medical center. Now, the ripple effect, which some of you may have read about or watched various YouTube postings about, from the medical community was mixed. And I spoke with nurses on really both sides of the fence as to how this came out. So many medical professionals say that Nurse Vaught's case could set a precedent of prosecuting medical professionals for honest mistakes. Now, what's an honest mistake? When an honest mistake results in a patient death and there were steps that should have been taken that were not taken, that's that line between negligence and then you get into recklessness, and then now you're into criminal recklessness and onward if it is intentional. As is stated here, the nurse was never charged with anything intentional. It was reckless. A second item is a notable item is that despite both drugs beginning with a V, the delivery process is exceptionally different, and the patient's condition should have triggered a warning to double check the medication. So one's injected directly, the other one needs to be mixed. So two very different processes for injecting a drug. And Versed is used more commonly, and so that's something that really should have raised a flag automatically as well. Again, this would not constitute an honest mistake. This is where you start getting into the more reckless side of the equation, gross negligence, recklessness, things of that nature. It was a rallying cry for nurses. So here is the timeline of the procedural events from January 2020 onward. And as we all know, in March of 2020, the pandemic was declared. So what we see are some peaks and valleys, some delays, and other steps that were taken during the course of this trial procedurally, which, if we weren't in the midst of a pandemic, would likely not have occurred. So on January 16th of 2020, Vaught's attorney filed a motion asking a county judge to overrule Cameron. Remember, that was the administrative judge from the licensing board, and delay the discipline proceeding until after the criminal trial. Now, as of February 25th, the judge had not ruled on that request. Fast forward to May 21st of 2022, and her professional discipline hearing is scheduled at a quarterly hearing of the Tennessee Board of Nursing. July 13th of 2020, her criminal trial is scheduled to begin, and again, the coronavirus delays both the discipline hearing and her criminal trial. So from here, we begin to fast forward, and July 22nd of 2021 is when the medical discipline hearing finally begins. That's over 14 months after when it should have taken place in May of 2020. Now, during testimony, the nurse did not shirk responsibility for the patient's death, saying it is completely my fault that she did not double check the medication she provided. But Vaught and her attorney also argue the mistake was made possible because of the flawed procedures at the medical center. At the time, they said that the medical center was struggling with a problem that prevented communication between its electronic health records medication cabinets and the hospital pharmacy. This was causing delays at accessing medications, and the hospital's short-term workaround was to override the safeguards on the cabinet so they could get drugs quickly as needed. And as the defendant stated, overriding was something we did as part of our everyday practice. You couldn't get a bag of fluids for a patient without using an override function. Now, harken back to what I said from the beginning, there should absolutely be an override function for certain situations, but it is not meant to be used all of the time. Unfortunately, this medical center is not alone in how its ADCs were and are being utilized, and the accountability as well as the documentation in the patient record often gets missed. So what she said is actually very valid. Now, July 23rd of 2021, the Tennessee Board of Nursing revoked her nursing license. The board members appear sympathetic to her case, but do not overlook her errors. The board's scope was also limited to the nurse, so Vanderbilt's actions could not be addressed. Recall, there's a separate board for facility licensure, but they opted not to take any action against this particular medical center. So in 2022, it's specifically March of 2022, the defendant's criminal trial begins with what's known as jury selection or voir dire. And jury selection, again, is set forth in the procedural rules. And typically, the prosecutor and the defense counsel have the lineup of potential jurors. And there are certain jurors which will automatically be dismissed by the judge. There are a certain amount of strikes that are given to each side of the aisle, both the prosecution and the defense. in order to automatically strike a juror for whatever reason they see, as long as it's not for an improper purpose or a racial purpose, something like that. And so that's the selection process that began. On March 25th, the trial ended. So that was a 4-day trial with a finding of Nurse Vaught guilty of criminally negligent homicide and abuse of an impaired adult. So again, she was charged with reckless homicide, and the jury came back with criminally negligent homicide. So again, that's further down the rung in terms of severity and scienter than either recklessness or first degree or second degree homicide, murder. So once we get into the sentencing, from my perspective, this is probably the most fascinating and really endearing part of the case. So as we know, the jury found the defendant guilty on 2 charges. She, however, was sentenced to 3 years of supervised probation, and the sentencing guidelines that a judge would have to follow. Again, this is state, this is not federal, but she could have served up to 8 years in prison for her conduct. But instead, the judge, as a judge does, has the ability to impart a sentence that they feel is reasonable in light of the circumstances. So she sentenced to 3 years of supervised probation. And alongside avoiding incarceration, the Davidson County Criminal Court Judge, Judge Smith, also issued Vaught a judicial diversion, a program in which first-time offenders can have their records expunged after completing their probation. So in light of the totality of the circumstances, which resulted in the death of a patient, and with the nurse admitting during her licensing board proceeding and during her trial that she did in fact have a role in the medication error, this type of outcome really is the best possible outcome. And it also shows the humanity of the judge, as well as what I would speculate to be the balancing of the impact on the healthcare system as a whole. So the defendant was held accountable, but not incarcerated and ruined for something that is deemed to be criminally negligent. Again, very different situation if it would have been intentional, completely different. So here, for those of you who are familiar with criminal proceedings in general, towards the end after the sentencing, the defendant or defendants plural have the opportunity to show remorse. And she did exactly that. Nurse Vaught said, saying I'm sorry doesn't seem like enough, but you deserve to hear and know that I am very sorry for what happened. And then the family in general said, knowing my mom the way my mom was and stuff, she wouldn't want to see her serve no jail time. That's just mom. She was a very forgiving person. Having said that, other relatives testified that her husband did want the defendant to serve time in prison. So again, it's a very emotional time for a victim of any type of situation like this. So the divergent response from the family members is not surprising. In terms of the public, the local media reported that the sentence was met with applause in the court's overflow room, and hundreds who were waiting outside the courthouse, many of whom were healthcare professionals. And really, again, in light of the facts and circumstances and what Judge Smith did, there really was a good balancing of the conduct, the first time offense, the negligent nature of the offense, which resulted in a very significant outcome, unfortunately. And then the balancing of the public and the healthcare system as a whole. As many of us know, there is a shortage of medical professionals across the spectrum, so that's very important. So as we round out the presentation, I wanted to leave you with a couple of key takeaways. So from a compliance standpoint, it is imperative to have ADCs configured correctly, limit the amount of end runs that allow for the safeguards to be ignored, and continuously train staff. One way to do this is through the annual HIPAA risk analysis. Anytime you, if you are an auditor, are evaluating a covered entity or even a business associate in certain circumstances, one needs to evaluate all of the sources of ingress and egress of protected health information. And having a penetration test done on ADCs is critical. Also reviewing the logs to see whether or not there were appropriate username and access controls is also inherent in the HIPAA security rule. So this is one way to integrate patient safety with HIPAA. A book which is absolutely fantastic, also tragic, is a book known as Josie's Story. And I actually attended a American Healthcare Executives meeting in Houston several years ago when now deceased Red Duke, who is a renowned trauma surgeon, was able to bring in the author of Josie's Story. And this came about because Josie was a toddler who ended up passing away because of the lack of controls and communication within the medical system. Again, a major renowned health center, John Hopkins. So I would implore everyone to read this story. It's very compelling, and it also gives some great ideas and helpful compliance tips, as well as some more practical ones of how families can be better communicated, how to make the stay as well as a process for families when a patient is being treated better in general. Next, was there joint and several liability, also known as aiding and abetting, since this is criminal, or co-conspiracy between the defendant nurse and the medical center? Joint and several liability, arguably so. That is not the path that either the district attorney nor the licensing boards took. Make certain that medical records are truthful and accurate, and employees should be trained on substantiating medical necessity and making sure that the SOAP notes and other types of notes are complete and accurate. Finally, disclosures to governmental entities, whether a coroner's office, CMS, or a licensing board, should be made in accordance with the law and in a timely manner with all material items included. And again, don't lie to a government agent. Normally, it ends up voting more unfavorably than it did for this medical center, but it's still something that is very significant. So with that, Catherine, I'm going to turn the floor back over to you for any questions that may have arisen.
Thank you so much, Rachel. This is really compelling and gives extremely thought-provoking. So thank you so much for this presentation.
My pleasure, Catherine. Hopefully it raises awareness for the listeners and attendees.
Certainly gets me thinking, and I'm sure it does for everyone else. We do have a few questions. So the first question that I have here is it common for parallel proceedings to occur?
In these types of situations, when you have a licensed medical professional and a patient death, absolutely, that would be a common occurrence because of the duty to report.
And then, could the medical center have taken more proactive steps to avoid this situation?
Yes, they could have. And one, as even the nurse and her attorney said, one step they could have taken was to have the system working sooner so as to avoid all of the regular overrides. The second would be to train the staff adequately. And the third would be to incorporate the ADCs into the annual HIPAA risk analysis. All of that in turn should lead to better patient outcomes and mitigate risk across an enterprise risk management vantage point.
Right. I can't help feeling a little bit because of those reasons that she was kind of
Used as a scapegoat.
that's exactly the word I was thinking, or held out to dry. I mean, that's just my
Yeah.
opinion, not anybody else's opinion here, but that's just my opinion. Yeah, because of those reasons.
A lot of literature on that, Catherine. A lot of people had similar sentiments. And so would every medical center or hospital have that outcome? I wouldn't think so. But
I mean, I thought it was pretty telling that she's every single time they used that cart or the system that they regularly had to override. I mean, on the other hand, the fact that to get the wrong medication, she had to, there were 10 times, what did you say, that told her that it was the wrong medication?
yeah, there were different safety mechanisms, such as reading the warning label, right? For anyone who has seen, I am not a smoker. I have never smoked in my life, but I think all of us have seen the warnings on cigarettes, right? Or alcohol that say you're pregnant or blah, 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 this can cause lung cancer. This is in bold. I haven't seen the vial, but probably in red saying warning causes paralysis. I mean, pretty telling. And this was pre-COVID, so it wasn't in even more stressful time where beds were at capacity and you had a lot of people dying simultaneously, really.
Right.
So there were other steps that should have been taken. And again, going in for a common diagnostic scan, a PET scan, a CT scan, an MRI with contrast, it would be a rare patient who would have a paralyzing agent rendered. It would be the Versed, which is just a sedative.
Right. Well, in any case, even if she had to do all those overrides constantly, then maybe she just got in this kind of rhythm of just ignoring all warnings, maybe.
Right, because when you let the safeguards lapse, it leads to complacency. Granted, she wouldn't have been the one stocking the cabinets. That would have been someone from the pharmacy. But even if the pharmacy tech or the pharmacist stocked the wrong drug in the wrong slot, that's why it's incumbent. And that's why in a lot of policies and procedures, the nurses play a vital role.
So that leads us to another question. What's your perspective then on the judge's sentence?
So my perspective is that under the facts and circumstances, it is the best possible outcome because it did not destroy her future, and the ability to have an event like that expunged so long as she adheres to the terms of her 3-year probation really gives that balance, like I said, between a wrong, right, that where a person should be held accountable, but not punished for the rest of their lives either.
Right. Well, really, really appreciate you giving this presentation today. It was extremely thought-provoking, as I mentioned, so thank you so much.
Oh, my pleasure, Catherine, and thank you for having me.
Yeah, I really appreciate it. Did you have any other words of advice you wanted to leave us with today, or any other thoughts on this matter?
I would just implore any provider, whether it's a medical professional or a facility or a third-party pharmacy entity that may be filling these, whether it's a hospital, a long-term care facility, an ACS, or a physician's office, to make sure that you do have the patient's best interest in mind and take the requisite compliance steps, because put yourself in the family's shoes. Having to lose a family member for something that was avoidable is
Mhm.
very hard for a family to hear, and something that will affect them for the rest of their lives.
Right. Okay, well, thank you again, Rachel. And attendees, please use the contact information on the screen for any questions. And if you think of any later, send us the questions and we'll forward them on to Rachel. Please remember your Paycom and PMI CEU certificate will be emailed to you from within 2 days following the broadcast. There's no need to request it. You can register for future webinars or request a demo of our compliance solution on our website at firsthcc.com or call us at 888-543-4778. And thank you for joining us.